We're on the record on Norcutt versus Council, D 16-537-499-D.
Okay, Council, Mr. Page, your appearance first, and if you're retained or unbundled. Unbundled, did you say?
Yeah, I think it was.
And Ms. Cooley, your appearance, please.
Cooley, phone number 8992, guardian ad litem for the child.
Duly noted, and I'd like to have Mom and Dad sworn in. Let me unmute the clerk.
Mom and Dad, please raise your right hands. You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Mom? Go
Yes.
Thank you.
Okay, thank you. So, if you're not speaking, it would help if you mute to avoid a lot of background noise. And what we're here on today is Dad's motion on because he lives here and Mom lives in Seattle, and Mom has primary custody of the child in Seattle. Dad's asking for a temporary change of custody, and as it pertains to schooling issues as well, until the trial. Let me just confirm, when is the trial set in this case? I'm pretty sure I gave you the dates already on that. It looks like you don't have a trial date yet. Oh, goodness. You need to set one. I thought that was set already. Okay. Let's get that one out of the way. In terms of the trial setting, we went through all that again before, how you might have a change of judge or even change of Department I judge with my impending retirement at the conclusion of this year. And it should be done as an in-person trial. Well, it's up to the new judge, okay, in terms of how the trial is going to be conducted on a change of custody. I have already approved pursuant to ruling that there's adequate cause to go forward on a trial for a change of custody, obviously in the best interest of the child, and that has to be resolved down the road. In terms of our settings, as far as the Department I calendar, no guarantee you'd stay a Department I judge assigned case. We're out to, and how many days, let me go with Mr. Page first, how many days would it require this custody trial? What do you suggest, Counsel? Would the witnesses you'll have on probably the emancipated son, he's 19 now, I believe, he will probably testify because as a witness, Mom will be a witness, Dad will be his own witness, unless he retains an attorney. Ms. Cool may be subpoenaed. She would have to be subpoenaed for a trial, and or she would come voluntarily once we know the trial setting. So if she has her calendar there, that would be helpful. And I highly recommend to the new judge that the guardian ad litem testify first, so that they don't have to be on standby for the entire time of the trial, so she can be asked questions on the record. Okay.
Well, if I may, I apologize, I don't mean to interrupt. If you would like me to appear at the trial, then I won't require either party to subpoena me. There's no reason to go through that expense if they don't need to. So if you would like me there and you think I would be helpful for another judge, then I will make sure that I am present.
Thank you so much. That would save a lot of legwork. Okay, and I said as an accommodation to you, Ms. Cooley, you'll testify first, so we can get you on and off the witness stand. Okay, I'll put that in the chat box. All right, I'll go with Mr. Page first, how many days he's requesting, then I'll hear from Mr. Counsel how many days he's requesting. And obviously, the whole calendar is going to be rearranged, but we'll try to keep keep your days together. Back-to-back days are a little bit of a challenge, but I will make it happen so you can have back-to-back days on this. Possibly like a Thursday and a Friday. I will give you sometime in May is the soonest I can do it. So if there's a decision whether he finishes out school in Seattle or school in Las Vegas, you're looking at around late May. I might have given out those dates, but early June for sure we could have dates. Mr. Page? Are you muted, Mr. Page? You're muted, Mr. Page. You have to unmute yourself.
Thank you.
Okay.
Ms. Coons already testified in her original report. She may testify as to her supplemental report. The overall son has already testified. So really all that's left are the two parties. I couldn't imagine that my client's case in chief, which deals not really so much with custody, because the prior report from the guardian ad litem stands on its own, plus the prior testimony, has to do with the order to show cause, dealing with Brad's continuing failure to pay child support and his total failure to contribute to the 529 account for the now emancipated son.
Right, okay. So in terms of days, you think 1 day, 2 days?
I will turn it out that 1 day is more than sufficient.
Okay. And Mr. Counsel? Dad?
I would safely say 2.
I can give you... Yeah, well then that would run us to... the first available is, looks like June 10th and 11th, back-to-back at 9 a.m. start time.
There's no way you could finish it out by the end of the year, Your Honor.
No, I can't finish it up by the end of the year because like with other trials, I'm finishing right now over Blue Jeans. This it's not going to happen in terms of the amount of exhibits that you have. And we already decided that the mom wants an in-person trial, and so I cannot override anybody's due process rights to have an in-person trial. And if we set it out that far in early June, either way, whatever the temporary decision is going to happen today, it will be the child will have a school year eventually, so they will finish out school, and early June would determine what, going forward on a permanent basis. I have June 10th and 11th.
Well, if that's the soonest, then yes.
Yes, it is on the department eye calendar now. You can file any kind of order shortening time of the trial. You can, but it's up to the new judge when they rearrange their calendar. You can ask them, but June is the first setting we can give you. When we expand and we have new family court judges on board, their calendar isn't going to be as filled as it is right now. I mean, we are really taxed right now because we lost a domestic judge to another division, and so Department L's cases have been redistributed amongst the remaining domestic relations judges. So that's why we're really feeling the crunch right now in terms of until they're expecting the new judges to take in and move in around the latter part of December and be ready to go the first full business day of January. So if you'd have to show something that's pressing, but whatever the outcome of today's hearing is going to tell you where the child will be attending school, obviously, because you put that motion now on the table today. So a school, whether here or in Seattle, that will be the temporary order until trial. So June 10th and 11th, let me put that in the chat box, and the JA will do an amended order setting trial. So JA shall file amended order setting trial for June 10th and 11th, 2021 at a 9 a.m. start time for 2 full days. That's stack number 1. That means you're locked in. And what you want to do, just a piece of advice, is you can find out who your new judge is and then call that new judge's secretary and say, look, we got this dates from Judge Moss. We want to know if we're locked in for sure because we need to prepare for trial and we need to know if these dates are firm. If they say yes, they're firm, you're good to go. If not, they'll say, well, can we have something a little bit earlier? And now that you're creating your own new calendar, they'll have a little bit more room and flexibility to move things around because they're going to get more breathing room than what our judges are currently experiencing right now. So they might work with you on that and say, you can tell them I'd like to get more priority, Judge, because we are an unfinished trial. Okay. Now,
do you have a timeline when that contact should be made?
after the election. So, well, they'll start moving in about after mid-December.
Okay, thank you.
So after mid-December, they're going to be taking a look at their calendars, and that's probably a good time to call them. Okay, discovery stands closed unless it hasn't existed. You know, like current school grades or future school grades, like school grades or progress reports. Yeah, of course, updated GAL reports. Okay, if it doesn't exist now and it's going to be coming forward, it's going to exist later. Discovery is going to remain open on those issues. So it's a trial of a trial. Discovery has already closed. Your trial exhibits are already in place. So a few supplemental exhibits, like what I mentioned there, is what I would expect. I think the judge wouldn't have any problem with looking at those. Oh, so anybody have any questions about discovery? It's already closed. We're looking at anything that doesn't exist that may later exist. And so you can bring those to trial. Okay, and we don't do anything, pre-trial memos have already been filed. I don't know if both of you want the option of submitting anything new, but I really don't think so. I think you're at a stage where you don't file pre-trial memorandums, you file trial briefs at the conclusion of your case. So check the rules on that. So trial briefs will be permitted by pursuant to court rules. So it's optional with both sides. Your trial, I meant trial briefs. Sorry. Okay. Any questions with that? What a trial brief is, look it up, and then that extra day I'm giving you is to allow for the final closing arguments of the trial, and I will forward on my notes. They'll stay in the S drive in our network there in the courthouse. They'll have access to the very detailed trial notes I've written. Okay? Any other procedural matters? I don't want to keep Ms. Queen online for the whole argument we're going to have today. I reserved it, and we're running a little half hour late. But we had Ms. Queen come back, and thank you for coming back, because I think we asked you to do any kind of supplemental report. And so we asked you to speak to the child one more time or a couple times. And why don't you tell us what information you've garnered from the child? How many meetings have you had? He must know you by now, Ms. Cooley.
The child and I met in person on August 26, 2020
All
at
right.
10 o'clock a.m. I would have to look at the report, but we've had a number of meetings. I don't recall exactly. I can provide that information, or I can just give you what we specifically talked about. When I started the meeting, I explained that who I was and that I was the guardian ad litem, and it was my job to help give him a voice in this process.
Right.
He remembered speaking to me previously, So that was good. And we talked, had a little bit of back and forth just about, what has he been doing and those sorts of issues, just to help establish rapport again. He said that he had been in Las Vegas for 5 weeks, and that his best friend is Gideon, who lives in Minnesota, Nico, but that they've grown apart, and that they play on PS4. And then he also mentioned, and I neglected to write it in that part, that he has his best friend in Washington as well. And I will come upon his name, I didn't write it down in this part. Gage indicated that he and Gavin are really close still. He said that he finished 7th grade and that his grades were C's and D's. And I actually reviewed his grades, and his semester 2 grades ending on 6/19/2020. For history, he received a C-. For science, he received a C-. For art, he received an A. Language arts, a C-, PE, a C-, and math, a C-. Based on his previous Washington grades, that has been an improvement. And based on the grades that he had while attending school in Las Vegas, that was also an improvement. My recollection is that his grades in Las Vegas were F averages.
Which one do you have in
In art.
A in art? Okay.
And that's actually, he has an interest in art.
Okay.
So that's definitely something that he's very interested in.
Okay.
He said that, his grades are improving and that he's working really hard on his grades as well as his behavior. And he talked a lot about this program that he's participating in called Release the Brilliance. And he indicated that this program is helping a lot with his behavior. And he really enjoys participation. I guess in 6th grade, Mr. Miller, and I talked about this issue, his school counselor, previously, but Gage said that he had punched a kid, but now that he's in 7th grade, after participating in Release the Brilliance, instead of punching the kid, that he's learned to walk away. And Release the Brilliance has an office on campus. So he said when he's mad or he's having an issue at school, he'll just pop in. And his mentors are Cheryl and Maddie, Mr. Matt. And that he works a lot with Mr. Matt. In Preston, he has 3 best friends. He has Washington, and then there's 3 other people in his group. But Preston is the friend that he's also kept in touch with on the PS4 while he's been in Las Vegas. With regard to school, he's currently attending Cascade Middle School, and he said that he wants to continue attending school there. He doesn't want to start a new school. He doesn't like CCSD. He doesn't think that the teachers are good and they don't help him. At Cascade, he says that the teachers help and they have a lot of patience. And if he's not doing what he's supposed to do, then he gets a warning and he stops. He said initially this school year he had a lot of contact with Mr. Miller, but since he's in Release the Brilliance, that contact has decreased and that's been a good thing. At that point we talked about whether or not he wanted to remain in Las Vegas, and he answered no. We talked about his preferences, and he said that he wants to go to school in Washington, that he wants to finish at Cascade Middle School, and when I spoke to Gavin, he mentioned that Gage wanted to go to Auburn High School. So when I asked Gage about that, he said that he's not sure what high school he wants to go to, but that Gavin will help him figure that out. I guess there are high schools similar to Las Vegas based on interests. So he wants to talk to his brother and get his brother's input and have his brother help him figure out what high school. With regard to interests, I know that football is a very big deal to a dad, and that's been raised. And when I asked Gage about it, he said that with regard to football, that maybe he'll do that in the future. But right now he wants to get his grades and behavior in order before he participates in football. And then, with regard to this, we talked about, what did he want to do for the summer, and he said that he would like to work with Release the Brilliance. He can work during the summer doing cleanup for $15 an hour, and he thought that sounded like something neat to do, and that he would like to be paid to do that. As far as his preferences as to custody, he said that he would rather stay with his mom full time. He says he feels very happy when he's with his mom, and that with his dad he has no privacy and no voice, and said that his dad did not trust him. He said that his dad was worried about slipping up. In the mornings, Dad would tell him Mom is lying and brainwashing him. When Gage would get to the YMCA, he said that he would be pissed off, and that the counselors would let him cool off for a minute. And he really appreciated that. I asked if he had fun this summer at the YMCA, and he answered no. And I asked why, and he said that at least once a week his dad says that his mom is brainwashing him, and that his mom is using Gage to hurt him and doesn't love you. He wants to stay with his mom full time. He said his mind has not changed. When he asked about the schedule, like he did previously, he said that he wanted to stay with Dad for spring break every 2 weeks, or for 2 weeks every year, and that's it. I said, what about Christmas, Thanksgiving, summertime? And he said, nope, it doesn't matter. I only want to stay with Dad for 2 weeks during spring break. When I asked why, he said that no one is going to tell him what to say. And he was adamant about that. As far as contact with his parents when he's with Mom and then when he's with Dad, he said that Mom sets a timer every night to talk to his dad between 9:15 and 9:30. And since he's been with Dad, he's only gotten to talk to Mom once every couple weeks. He said every 2 weeks. He said sometimes he forgets to call Mom. He said that his dad doesn't remind him to call Mom, and that he wants to talk to his mom more because he misses his mom, Gavin, and his cat. His cat is Nomi. He got as a Christmas gift in Las Vegas. He calls her his support animal, and he said that she is there waiting for him at home. And she likes to lay on his chest and back. And he recited a story that when he leaves to walk to school, Nomi is sitting in the window waiting for him to come home. So it sounded quite cute. And Nomi likes to sit in his chair that he uses at the computer because it smells like him. Let's see. I talked to Gage about his cell phone. And he said that he left his cell phone at Mom's because his dad will ask for the password, and if he wouldn't give him the password, then his dad would take it. And his brother Gavin suggested talking through the PS4. When we talked about schedules at Mom's house versus Dad's house, he said that his favorite thing to eat at Mom's house is lasagna, and that he eats with Mom, And at Dad's house, Dad cooks spaghetti, but he eats dinner in his room. I asked about Suzette, and he said that he gets awkward, weird vibes from her, and that he doesn't think that she likes him. He was very excited that he just learned to ride a bike in Washington. Gavin and Mom helped him, and Gavin was so proud of him. We talked a little bit about the wedding that he's going to over Labor Day, so I guess that happened. As far as when online school starts, it starts September 9th, and he said that he is, quote, not excited for online school. But when I asked whether he would do online school in Washington or in-person school in Las Vegas, at private school, he said that he would rather do online school in Washington than private school. And when I asked why he didn't want to go to in-person school at a private school, he said that he doesn't fit in at private school and he doesn't want to go. He said he's looking forward to going home, and I asked what he meant by home, and he said Washington. And I said, well, what is Las Vegas then? And he said that that's Dad's house. At the end of our conversation, I, asked if it was okay if I talked to him again before he left to return to Washington. And he said that his dad records the phone calls, and he asked me not to call him on his dad's phone. And he thought that this meeting was enough, and that he and I did not need to talk again while he was at his dad's house, and that his opinion of his wishes and preference had not changed. So that's my update in a nutshell.
Okay, thank you so much for the update. Does either side have any quick questions for Ms. Cooley about her report to the court, and then we'll get into the motion argument.
Ms. Cooley, did you speak to after you got back to Washington?
No, I did not. Gage, in this last, in this meeting that we had, he said specifically that this meeting is enough, and I wanted to respect his wishes. In the event that the court or the parties ask me to talk to him again, I will happily do so. But I thought that it was important to give him, to respect him in that manner.
Did you have some difficulties in getting Gavin to your office?
Well, Gavin's not here.
You mean Gage?
I said, did you have trouble getting Gage to your office?
I'm not sure what you mean exactly.
Did Dad give you resistance in bringing Gage to your office?
Initially, yes.
What did he do?
When I indicated that I would like to meet in person with Gage on August 26th at 10 a.m., and I'm looking for the email, he responded that, let's see. My new search function is very strange, so,
I think the question is, was Dad doing anything intentional to hold it up? Or
Well,
communication?
my my question to Mrs. Cooley in an email was basically my concerns were about the health factors, the COVID, the safety. Is our office clean? Is it taken care of? Are there concerns? I put all that in an email. That's all I was saying.
And actually, I have the email, and I wanted to read it because I don't want to put words in Dad's mouth. There was a little bit of back and forth, but Dad did eventually agree. So I don't know if you want me to read the email or...
No, that won't be necessary.
Okay.
Any more questions, Mr. Page?
Was there any resistance in you being able to have privacy with Gage when you spoke with him?
No. I spoke with Gage in a conference room, and, Dad said, well, what time do you think I should be back? And that was it.
I have nothing further then.
All right, Mr. Counsel, Dad, do you have any questions on this query? Just briefly.
Yeah, like I said, the term resistance has to be removed from record, and the fact that the term was concerned. I was concerned with COVID. I didn't know what type of environment we were walking into, if it was an office, if it was clean, if it was disinfected.
I have no issue with that, Dad.
Okay, well, once Mrs. Cooley assured me that it was safe, then everything was fine. One thing that I would like to point out that I also submitted this afternoon as exhibit number 9, Your Honor, is the fact that the barrage of emails from the other party to Mrs. Cooley, in my opinion, trying to influence and persuade Mrs. Cooley and her direction on once more fraudulent statements and statements that were already argued previously and litigated with no findings whatsoever. Again, I responded in only defense to myself. I submitted the complete emails this afternoon for your eyes, if you've seen them. But, Mrs. Cooley, would you...
have a question, though, from Ms. Cooley? I think what Dad's trying to imply here is it concerning, and should it be concerned to the court that you've got a lot more emails from Mom than you did from Dad, or, is that part of the process to, emails?
I received emails from both parties and, told them repeatedly on more than one occasion that I was the guardian ad litem. It was my job to help the court determine their son's wishes and preferences and what was in his best interests, and that the allegations and claims that they were both raising needed to be brought to the court, not me. And I had to remind the parties multiple times that, these allegations had nothing to do with me. My job was to talk to Gage and find out what his wishes and preference were, and that I wasn't, I'm not an attorney for either of the parties. I did not need
that being a family law attorney. How long have you been a family law attorney?
16 years, I think. I don't even... 2004.
Sounds about right.
Yeah, I think that's the right math. I don't know.
Distinguish from when a party is trying to work you over? And
absolutely. And I shut everybody down because I'm neutral. I don't care what their specific allegations are. I want to talk with the kid.
Right. Any other questions, Dad?
Yes, I have one more to Mrs. Cooley. Mrs. Cooley, do you find it odd that Gage made statements versus that Gavin, his older brother, which is a brother, would help him determine his educational future rather than his own father and or mother?
No, and the reason is I know that Gage and Gavin are very close, and
you know that? Like, how do you know that?
I do not do an independent investigation as far as going to homes and, checking things out
So
necessarily.
you assume with what you've been told.
Well, it's just her impressions from talking with Gage.
Impression.
And, yeah.
Okay.
Yes. Yes, based on what Gage and Gavin have said, they've both said that they're very close.
But that's a normal relationship with a brother and brother, right?
That's my understanding, yes.
Okay. Or sister and sister.
With these children, yes.
Right.
Given their ages, yes.
Right. But normally, wouldn't a 13-year-old child would like their father and or mother to help them with their future or guide them? Experience.
I don't know that I'm qualified to answer that question.
I think she just would relay to the court what is Gage saying, what is the impression she's getting from what Gage is saying.
Understood.
Yeah. Okay, any other questions? Because you've got to argue your motion, Dad.
And then, when you were speaking with Gage, did he give you information freely, voluntarily? Did he appear to be under any influence or just
Coaching, anything of that sort?
No, he actually, it was kind of funny. When he was talking about, Suzette, and he said, yeah, I get vibes from people, and I'm like, really? And we're wearing masks, certainly a sterile sort of situation. And I said, really? So what kind of vibes are you getting from me? And we were sitting across at, a big conference table so far apart. He said, I think you're cool. And I was like, really? I'll have to tell my kids. Some kid actually thinks I'm cool. So, it actually, in GLO cases I've had situations where it took a lot of contacts before the child was free to speak with me, and, you could tell that the dynamic changed and they became more comfortable. Gage, I haven't gotten that from him. He and I have from the beginning, conversed fairly freely.
And the question was he genuine in his responses, Ms. Cooley, now that you felt that the ice was broken? And you always keep an eye out for that, right?
Absolutely, yes. And what I found interesting is that, based on overhearing some of the arguments, at the last hearing, or maybe the second to the last, one of the last hearings I was at, one of the allegations is that, Mom claimed that Dad was going to, unduly influence the child, and, that he would do an about-face to, what we were, to, the information that I provided in my previous report. And that wasn't the case. I actually found his, his wishes and his reasoning to be consistent between my initial information provided in my report. So I didn't find that there had been, any influence, and that, based on the allegations of both parties, Dad says X about Mom, Mom says Y about Dad. Gage was consistent, which I believe that to mean that he's maturing and he's becoming his own independent person and thinking for himself. So I actually, I don't know that I would give all, kids his age, I guess, not deference, give weight to their wishes and preferences. But I think in Gage's case, I think that he is maturing nicely and is figuring out who he is and is becoming independent. And I think that he is of significant age and maturity to form a preference.
I have one other, I do have a couple couple other questions real quick, Your Honor, if you don't mind.
I'll leave. One quick question. Yeah.
Did you notice that Gage had anything on his arms? Like jewelry or rubber bands or anything when he was in your office?
I did not notice.
Okay. All right. And also, you mentioned an after-school program or Realize Brilliance or
Release the Brilliance, yes.
Release the Brilliance, right? And
I'm sorry. No, it's called in one place I have Release the Brilliance, and another place I have Unleash the Brilliance.
Maybe
Release Brilliance.
I'm not sure which one it is.
Mom, do you know the name of the program, Goldie? Do you know the name? Is it Unleash or Release?
It's Release the Brilliance.
Okay, I got it right in the chat box. Okay.
Okay, and did you?
Thank you.
Okay.
Oh, thank you. And Mrs. Cooley, you brought up his grades, but you did not point out that his grades throughout the entire school year. Did you look at his entire education report all the way back to going back to the 5th grade before he was relocated to the state of Seattle or the state of Washington?
I don't think that's her role, Mr. Counsel. I think she's just to ask the child, hey, what's going on? How are things?
I understood. I only brought that up because she looked at it.
Ask Miss Cooley if she looked at the prior grades, and she can answer yes or no.
I did in my initial report. I looked at it, and I also looked back at that when I compared his semester 2 7th grade grades to where he was in Las Vegas, and then where he was at the time that I did my report.
Okay.
Okay. All right. So just making sure that you understood that even though he still had in 7th grade as submitted to the court in the exhibits 3 pages of behavior issues still at school that's been filed. So my concern is that maybe you did not see or were not aware.
I think Dad is asking if Gage is trying to pull one over you, Miss Cooley, because of his behavior problems at school. That is he purposely trying to portray himself in a positive light? And does that change his wishes or preferences? And you don't find any coaching from Mom in that regard. His level of maturity and his rationalizations, yeah.
No,
That's more of Dad's question.
right. No, I didn't find that in Your Honor. I spoke with Cheryl, who runs Release the Brilliance, as well as Maddie, who's also a volunteer with Release the Brilliance. And I asked about the behavior because I had been provided with Dad's motion, and I saw the exhibits.
Mm-hmm.
And I asked about that, and because they monitor that. They have meetings, they talk about it weekly, they work with kids, they're a presence on campus. And they specifically said that, if you were to compare his behavior reports from, 6th grade to now, you would notice that, initially it was for physical stuff, for physical conduct with other students, and that, that the behavior, well, it wasn't perfect, it was improving, and, that they had seen an improvement.
I guess my concern is improving an improvement, an excuse to still misbehave, because in his discipline reports from school still shows the violence, the lack of respect assaults, such and so forth, if you would look at his behavior report provided by the school. Also, you stated the word campus. Is this on school, or is this a school activity? Is this provided by the school? Because also in my exhibits, directly from his school counselor, Mr. James Wright is his school counselor.
Right.
Mr. Wright clearly states that I don't know that Gage is attending any before or after school programs at all that would support. So I find it funny that his school counselor has no knowledge of any program that he's participating in on or before school, clearly. And I think that it would be highly doubtful that the entire truth and all the truth has been truly conveyed as only as a mirage that I see, having no knowledge of any unleashable or anything that I think that would be conveyed between two parents that your child should attend.
I don't know. Dad's saying that one part of the school, the left hand's not talking to the right hand, or he doesn't say that.
His school counselor should know everything about him. That's what a counselor is.
Your Honor, I can actually address that. When I was speaking with Cheryl, the program director, he said that the school counselor recommended Gage for this program. And that's, a school counselor or a teacher has to recommend a kid, and Gage was recommended. So that's why Gage is actually part of the program. I don't know what
if that's, again, the discovery is closed, it's important. I think the parties can subpoena to have those parties testify over Blue Jeans. You can't fly a school counselor into Las Vegas, obviously, but I would appreciate the school counselor, Dad, if you want to, try to establish facts, and hear it from the horse's mouth, I guess. So,
understood. I was referencing back to March 20th.
Okay. Now,
March 9th, 2020.
I have to just say this. We have to normally quit at 5 o'clock. I owe you guys about a half hour. And we had you set for, what time, 3:30? We didn't get going until 4. And so, we were already going to go into overtime, and it depends on my availability of my court clerk to do the recording. And so I'm trying to get approval right now. Let me see if they sent me a text. She could stay until 5:15, and it is at 4:55 right now, and I can't hold the clerk past 5:15. So I've been nonstop all day. I mean, I've got bags under my eyes. I've been nonstop since 9 a.m. and we kind of basically worked through lunch hour. I've had cases. These are the cases that are just taking 2 hours. I mean, a lot of them are departmental cases, so, oops, I said that on the record, but, I have no choice. As a judge, I have no choice what cases are assigned to me, and I'm getting a lot of rough ones from departmental. But I'm not, I love my colleague, Judge Gibson, but it is what it is. It's just, my calendar, they're only limited. They only work till 5 at the latest, and I've got a clerk that has to leave by 5:15. The
labor schedule?
What I'd like to do, and I think we spent this whole time talking about regarding the litem's report. I did not anticipate, the allotted time, and this is an important motion. This is one of those, this motion, whatever the outcome is, it's obviously important to both sides. So I want to give them their adequate due time. The last remaining, 10 minutes before I release the courtroom to lock up and clean up and cut the lights off, they got to be out of here by 5:15. So I will use the remaining time, but before we forget, Helen, is Susanna there in the courtroom?
No, she
I sent her down to talk to you about how available you are.
No,
but,
she's not in the courtroom. I received an email from her.
You probably went back upstairs. Can you ask her to find, or maybe you can help me find an appropriate well, let's see. Let's just get that out of the way right now. Or try to dial Susanna if she can just help us find a spot. I want to have it right away because people are prepared to argue this today, and we have, it has to be convenient. We won't need you, Ms. Cooley, once we're done with you today. This is Jad's going to argue his motion, Mr. Page is going to defend against it, and then I have to make a ruling on a temporary basis.
Do you want me to exit the call, or?
Barring any questions, I think we're kind of done with that, but I'll still entertain a few more minutes if Mr. Page or Jad has one or two questions. I'll listen in while I'm multitasking here and trying to find you. I want to check with Susanna. I really want to lock in. I'm trying to get availability tomorrow, but Mr. Page, are you filled in the mornings for hearings tomorrow? You gotta unmute yourself, Fred. You're still muted?
I'm muted now. I've got 4 hearings tomorrow morning.
Oh, cool. Okay, and then I've got a trial starting at 2 o'clock, one of my unfinished trials. How are we looking for the 11th? Friday, 9/11? This doesn't involve Ms. Cool at all.
Your Honor, you have availability on 9/11 at 9 o'clock in the morning at this time.
I've got a status check, but that doesn't impact my schedule. We can go straight, we can get this motion done and over with and argued from 9 a.m. until, and if I put you guys on time limits, considering the contentiousness of this case, 30 minutes for your main arguments. Hang on a second. Susanna was IMing me, but I was like, that's no good because Mr. Page's hearings all morning tomorrow. 9 a.m. to 9:30 for Jad at the party. 9:30 to 10 o'clock for Mr. Page to oppose. Rebuttal from Dad from 9 to 9:15, and any 2-minute solo rebuttals. Finish up by 9:30, and hopefully I'd like to get an oral decision unless I choose to take it in their advisement and write it over the weekend or something. So, can we be available Friday at 9, Friday morning?
Yeah,
Yes, Your Honor.
Friday at 9, I just don't know that we need that much time. This has been,
We don't have to
we didn't need that much time to summarize what's really occurred.
No pun intended, but I can gauge what kind of time limits I would allow the lawyers, so, and the co-per representing himself. Okay, so, yeah, this is the time limits. Helen is taking note of this. 9 to 9:30 with Dad, 9:30 to 10 if Mr. Page wants to use all of his 30 minutes. If he doesn't and he's done, then he's done, and then I can allow 10 to 10:15 for Dad for rebuttal, and then he gets the final rebuttal technically, and then the remaining 15 minutes can be for like brief solo rebuttals, and then we'll be ripe for decision.
Your Honor, can I respectfully request an additional 15 minutes at 9:45 instead of 9:30?
This is
I just have I have additional factors that I would like to present that just.
An extra 15 minutes isn't going to hurt me, Mr. Counsel, so yes, and it's a very important motion to you and to mine, so I have to defend it, and so let's do a little modifications here. I'm going to put it in writing so we don't have any questions. 9 to 9:45, Dad, and then 9:45. You're taking up my whole morning, but I will indulge since you guys were so patient with me this afternoon. 9:45, 10:30, Mr. Page, Attorney Page, and then 10:30 to 10:45 with Dad's final rebuttal. We'll find out with Dad's rebuttal. And we call them solo rebuttals. They're about 2 to 5 minutes. It's so late in the day I'm trying to spell. Solo rebuttals. From, 10:45 to 11. Those should be You might finish early, depending on how much time you want to use. And then that's how it works with a motion hearing. Okay, your sort of rebuttals. And then concludes at 11 unless I choose to do an oral decision under best interest of the child factors and Ellis versus Carucci standard, even on a temporary motion, or I choose to write it over the weekend and issue a minute decision in that regard. But I will be available on Friday. I'll make myself available. Okay, any more last minute questions? Very, very quick questions.
Yeah, I do, actually. I have one more for Mrs. Cooley. Mrs. Cooley, your initial report, when you filed this way back when, I don't know the dates, I'm sorry. But how much time did you invest in that? Did you wait till, per se, the last minute to reach out, or did you put some time into really look into factors? Because my knowledge is that it was last minute, and my concern is that I understand your role and I respect your role, absolutely, is that the fact that a decision of the magnitude may not properly reflect some of the statements that you have made, and in fact that, over time, yes, he has matured, but the influence has still been put in place. So my concern is that how much time...
Let me see if I can translate in a concise.
Yeah, I'm sorry, Your Honor.
And Ms. Cooley's been doing this family law thing for a long time, so I think she knows.
Right.
Basically, the maturity level of the child, we want to make sure, the GAL is, has been aware that the child's statements to you are a true reflection of his own independent thoughts and feelings, considering obviously the mom having the primary custody and having the most of the time being spent at her household, then apart from summer vacation with Dad. So you understand the concept, Ms. Cooley? Is what Gage is saying truly what he's saying, considering Dad's concerns that he might think there's a lot of pressures on him to say things one way or the other? Is he able to think maturely and independently on his own, is the question.
I believe so, Your Honor. And I would like to address Dad's comments. I started interviews with people on November 14, 2019. It's outlined on page 2 of my report. I spent between 5 and 6 hours interviewing various folks. I talked to Mom. I talked to Gage multiple times. I talked to Dad and the brother. I spoke with the school counselor, Jim Wright. I talked to the mother of Gage's best friend, Preston. I spoke with Dad. I spoke with Gage, and I spoke with Danielle Esquivel. So I had a number of contacts. They also reviewed all of the pleadings in the case. And I think I spent probably close to, including the time I spent interviewing, approximately 30 hours writing the report.
Right.
So I wouldn't characterize it as last minute. I didn't spend months and months interviewing the kid, but that's not typically what the GAL does.
Well, I understand. Let me rephrase my question. Is that the fact that it seemed that, to me, that you reached out a week before the trial, basically it was almost a week before the trial took place, and the fact that statements have been addressed that were already previously argued in court and settled, and that was just my concern. That if you're going to, I understand you're doing a pro bono, but you also state that you've had numerous of conversations with Gage. I I've only been aware of 2 conversations. The first report that you did, then we did a interview with